Okay, this is the last video of this week, and we're going to talk about agency. What is an agent? What is a principal? First thing you need to understand is that how business organizations are held responsible for acts of their agents. And remember, employees are agents of companies. So that's one of the major things we're going to be looking at. We're going to look at the laws and also the limit of at-will employment and some of the ways a company can protect itself. But first of all, let's see what is the agency relationship. There are three parties in an agency relationship. There's the principal, there's the agent that have an agreement among themselves, there's the agent and the third party. Agent can either be a tortfeasor where it's injured the third party, or it can be in a contract where the agent has entered into a contract on behalf of the principal. And the relationship between the agency and the third party is then the relationship between the third party and the principal. Agents can bind principals, and agents can bring liability to principals. When you say principal, think of employer, and when you hear agent, think of employee. So in the case of a tort, you have the agency relationship that is laid out before, but now the agent has injured the third party. Harm was caused, and it was within the scope of the work of the agent, or within the responsibilities of the agent. Then the principal, the employer, is liable under the concept of respondeat superior, that the principal, the employer, is always responsible for the actions of its agents if it's done within the scope of the employment. So you have a company, you have a driver, they take their car, they're doing on company business, they pull off onto the highway and they run somebody over. There will be two people named in the lawsuit: the tortfeasor, the agent, the employee that actually did it, and the principal. The company will also be held liable because this was an action caused by an agent within the scope of their work. In contracts, again, you have the agency relationship between the principal, the agent, and the third party. But in this case, the agent was the party that negotiated the contract. And the contract, if it's within the scope of the agency, then the contract is binding on the principal, so long as it was authorized. You have express agencies, which are very open, very specifically. You have implied agencies when a principal and an agent do not expressly create, but it's inferred by the conduct of the parties. If a principal is taking a potential salesperson around to clients, introduces them as their newest and hottest salesman, and then they don't hire him, and that salesman comes back a week later and puts up an order, the agent, the principal, will be responsible. The agent breached their duty to the principal, but nonetheless there was an implied agency. And if an agency can occur when a person that is misrepresenting himself or herself as another's agent, when in fact they are not. Normally the principal would not be liable. But if the principal ratifies the unauthorized act, then the agency relationship is established and the principal would be held liable. You have employer-employees. These are principals and agents. And you have a relationship that results when an employer hires an employee and gives the employee authority to enter into contracts. And you have principal and independent contractors. What I want to spend some time on is looking, though, at the contract liability of principals and agents to third parties. This is contract liability. We're going to talk about tort in a few minutes. Okay, a fully disclosed agency. Everybody knows that the agent is working for the principal. The principal is liable. The agent is not liable unless the agent acts as a principal or guarantees the performance of the act. But a principal and employee is not liable if the principal, the company, does not fulfill a contract. Everyone knows the employee is an agent. A partially disclosed agency. This is when the principal would be liable. The agent is liable unless the third party relieves the agent's liability. So this could be that a person says, I am not able to tell you who I represent, but I'm going to sign this contract on behalf of a principal. Unless the agent is specifically waived, since the third party does not know who the principal is, then they will hold the agent responsible. You can also have undisclosed agencies. This is where the agent is working secretly for a principal. The principal is liable when that is found out, but the agent is also liable because that's where the person thought that the person signing the contract was in fact the principal. This would happen in situations. It happened many years ago in Florida when Disney wanted to buy up a lot of the land around what is now Disney World. They knew if Disneyland was known to be the buyer, that everyone would raise their prices. So they sent a number of agents in there that had an undisclosed agency. They were buying on behalf of Disney, but nobody told the sellers that it was. If Disney had forfeited on those contracts, then the agents could, or the third party, if they discovered that undisclosed agency, could have sued Disney, but the agent themselves would also be liable. A non-existent agency, principal is not liable unless the principal ratifies it. Somebody comes by and lies and says that they're the agent. Obviously, that person would then be liable. And they're also liable for breaching their implied warranty of authority. And exceeding the scope of the authority, principal is not liable unless ratified. The agent is liable under implied warranty. So you have some situations where the agent is liable even when they are acting on behalf of a third-party principal. To recover, the plaintiff must show reliance and ignorance of the agent's lack of status. That's when the principal is not liable if the agent is exceeding their scope of authority. Next is tort liability. The liability of principals and agents to third parties when the agent is actually the tortfeasor. Misrepresentation by the agent's liable. The principal is liable for the intentional and innocent misrepresentations made by an agent acting within the scope of her authority. So if the principal is, or the agent is making a negligent act and they're still doing it within what they think is the scope of their authority, then the principal is also, both the agent and the principal will be liable. Negligence by the agent. The agent is liable. You notice in this case, in any tort, the agent is always liable. The question is whether the principal is also liable. Principal is liable under the doctrine of respondeat superior if the agent's negligent act was committed within the scope of employment. That becomes the big issue. Was it done within the scope of the employment? And then an intentional tort by the agent. Agent's again liable. The principal is liable under the motivation test and the work-related test. Normally they would not be liable, but if it's done as a part of their work, the person is a bouncer, they punch somebody in the nose, the principal will be held liable. What is within the scope of employment? Many law cases have been looking at this. The act was requested by the principal. The act was in which the act was for the employment, is for the employer. It was within the time period of employment, within the location of employment authorized by the employer. Was the agent advancing the principal's purpose when the act occurred? Interesting case of a checkout woman at a checkout stand in a supermarket got very upset with the customer, reached across, grabbed the woman and banged her head against the conveyor belt because she'd said something to her, something like that. Certainly not within the scope of employment. But the employer will often be held responsible for selecting the agent. And so if a company hires a agent that a little bit of due diligence would have shown that they have a criminal background or a propensity toward violence, then they will be held liable because they hired a person that they should have known. Okay. Whether a person is an employee or an independent contractor has a lot to do on whether or not the employer will be held liable. And in this is a number of different tests that you can look at. It shows that, for example, does the employer exercise a great degree of control over the details of the work? Then it's probably indicative of an employee. And if not, it's an independent contractor. None of these by themselves are definitive, but it's a matter of the weighing of all of these as to whether the court will find that it was an employee or an independent contractor. Because independent contractors actions are not liable for the principal. They're being hired. The principal is not liable for the independent actions of the independent contractor, except when it is extremely dangerous work, or that the independent contractor is doing specifically what the principal had said. But otherwise, negligent acts of the independent contractor does not bring liability back to the principal. Okay, those of you that do work for hire, if you're an independent contractor, you own the copyright or the patents of the work that's been worked on, unless it's contractually said otherwise. But works for hire, company owns the rights of work that's done during the normal employment. Your duties of agents and principals, it's a fiduciary duty. Agent must have the highest standard of loyalty, performance, obedience, notification of the principal of anything that's happening, a full accounting. That is the responsibility of an agent to the principal. There are certain exceptions of the agency, even though it is an employee and it is an agent of a principal. Frolic and detour is when an agent does something in the course of his or her employment to further their own interests rather than the principal's. Principal's generally not relieved. The general is relieved of liability. Somebody decides to go watch a movie at 2 o'clock in the afternoon and they hit somebody on the way to the movie theater. That is frolic and detour. That is not part of their job. Coming and going rule is that the principal is generally not liable for injuries caused by its agents and employees while they're on their way to or from work. The exception, don't you love those exceptions? Dual purpose mission, you may be asking somebody that's headed on the way home to stop by and drop a deposit off at the bank because it's on the way. They're more than happy to do that. If they hit somebody on the way between the company and the bank, it's during the time that they were on the clock and the company is liable. If it's from the bank to home, it is coming and going and the employer is not liable. Okay, a couple of laws you need to know about. Family medical leave, the FMLA, what the circumstances are that would be allowed so that a person can take time off. Be aware of OSHA, Occupational Safety and Health Administration. They're concerned with hazardous conditions in the workplace. The employer has a duty, a legal duty, to have the workplace free from recognized hazards. OSHA has a right to inspect, and if they are notified of safety violations or safety problems, that person cannot be fired for notifying OSHA. Employment at will. Oklahoma is an employment at will state. Employees can be fired for no reason at all. The employer just decides they want to fire them. However, there are certain reasons that are prohibited. You may not fire somebody for illegal purposes such as discrimination. Age, sex, we'll be talking about this next week on discrimination, but you cannot fire somebody for a reason of discrimination. You cannot fire them for doing their public duty of military or jury duty. You cannot fire them for being a whistleblower. And you cannot discharge them for exercising their legal rights. So you can fire people in Oklahoma, but it has to be, again, for the right reason. Workers' privacy. Employee has access to their personnel files. It's restricted to third parties. Private employers are restricted on asking for lie detector on application screening and some drug limitations for drug testing. But use of personal computers is not private. Computers are owned by the company. The company has the right to see what's going on with them. So anything you put on a computer in the office is open for anybody in the office to see. You do not have the right of privacy to use the employer's computers. How can employers protect themselves from employee lawsuits? Create a paper fortress. Put in job descriptions. You have personnel manuals. Let people know what's expected of them, what's not expected of them. Keep good personal files. Written warnings, signed and noted. Letters of explanation. If somebody is doing a bad job, document it. If you don't document it, then they're going to come back and possibly sue for a wrongful discharge. And if you say you're going to do it, follow it. If you say it in a employee's manual or in a hiring form, or if it's a general policy, then the company will be held responsible to that standard. It's a standard you set for yourself. Okay, that's all for this week. I'm looking forward to your forums, the test, and we'll be done with week 4.